Okay, moving on. Next up, page 7 of the calendar, Nathan Vincelette versus Affinity Lifestyles.
Morning, Your Honor. David Gutke on behalf of defendant Hanna Instruments.
Good morning, sir. And don't we have other appearances on this matter?
There have been no more check-ins on this matter.
Okay, which surprises me. Okay. Anyway, for the record, I just want to make sure we have this correct. This is defendant Hanna Instruments motion for determination of good faith settlement on an order shortening time. And it's my understanding there's no opposition, is that correct?
That's correct. No opposition.
Okay, we'll go ahead and grant that. Okay, and then we have an issue regarding the other, we have bankruptcy going on.
It's for Brian Dower.
Okay,
Submitted orders and how they affect Milwaukee.
okay, we don't. Let's see. Well, this is Hanna Instruments, not Milwaukee. Right?
Hannah's off in this.
That's correct. We represent Hanna Instruments.
Yeah, not Milwaukee. That's one of the things I've been wondering about, what happens with Milwaukee. Yeah, anyway, we'll go ahead and grant that, sir.
Okay, perfect. Thank you, Your Honor. Have a good day.
Enjoy your day, sir. Okay, next up, page 23 of the calendar, Hunter Brown versus Affinity Lifestyles.
Morning, Your Honor. Jim Cavanaugh, one LLC, DBA Terrible Hurt. Morning, Your Honor. Eric Pepperman and Teddy Parker for plaintiffs. Good morning, Your Honor.
Good morning. We have
Good
other.
morning, Your Honor. Colt Dodrill, bar 9000, counsel for Nevada Beverage.
Good morning, sir.
Matthew Sarnoski, 9176, specially appearing for Silver Springs.
Good morning.
Lorraine
Your-
Frister, 13217 for Kahee Distributors of Nevada.
Good morning.
Good
Good
morning.
morning, Your Honor. Jim Neal, Robot Vice for UNFW and Whole Foods.
Good morning, sir.
Good
Trisha
morning, Your
Dellis.
Honor. Duncan Justice, ProHoc VJ on behalf of Costco Wholesale Corporation.
Good morning.
Trisha Dellis Santos, bar number 15902 for defendant Costco.
Good morning, ma'am.
Morning.
Is that it? That's all check-ins? Okay, I guess we have two matters on calendar. First we'll deal with would be plaintiff Daniel Taylor and defendant ETT LLC's joint motion for determination of good faith settlement as between plaintiff Daniel Taylor and ETT one LLC and DBA Terrible Herbs. Right?
Correct, Your Honor.
Okay. We can get started, sir.
It's unopposed joint motion, Your Honor.
Yeah, that's my understanding too.
Yes, Your Honor, that's correct.
Okay, we'll go ahead and grant that, sir.
Thank you, sir.
All right, you can submit an order in the inbox. Has one been submitted?
I don't think so.
Okay,
Can I just, at this point, I think the next motion is going to be plaintiff's motion to amend.
correct. You can, if you want to leave, you
because
can
of the
leave.
Granting of the, sorry, sir.
If you want to step out, you can, sir.
Well, I just wanted to make clear that because of the settlement between my client ETT one LLC and plaintiff Daniel Taylor, it renders the opposition of my client and my client only is opposition
I understand.
moot. So we would withdraw it on that basis.
Okay, and thank you for clarification, sir. Does plaintiff's counsel agree?
Yes, Your Honor, and
Okay.
I would also add to that, the motion is not before you, but subsequent to the filing of our motion to amend and the opposition by Silver Springs related to the amendment of claims by Steve Watkins, Mr. Watkins and Silver Springs have also agreed to a settlement. So Silver Springs opposition to the motion is moot as well.
All right. So we have, I guess, moot would be ETT one and Silver Springs.
Yes, Your Honor, and that leaves only Nevada Beverages opposition to the motion related to the claims by Daniel Taylor.
Okay, I understand, sir. All right, and I guess that's clear for the record. Is that correct? Everyone? Okay. So let's go ahead and continue on and focus on the motion for leave to file an amended complaint. So,
So, Your Honor, as I said, the only relevant issue here relates to plaintiff Daniel Taylor. He sought to amend his complaint to clarify that his claims apply to both Terrible Herbst and Nevada Beverage. Terrible Herbst and Nevada Beverage filed a joint opposition saying, oh, you can't amend, it's prejudice, it's undue delay. Subsequent to that, Terrible Herbst settled the claims and repudiated all its arguments. And Nevada Beverage, I believe, is still maintaining its opposition. From plaintiff's point of view, Your Honor, this is a Rule 15 motion. It's granted with extreme liberality. The strong policy in Nevada favors trying these claims on the merits. Plaintiff's motion is timely. It was filed well more than a month before the deadline to amend pleadings. Terrible Herbst and Nevada Beverage were both in the real water action since 2021. And in this particular complaint that includes Mr. Taylor since early 2023, because Terrible Herbst was in and Nevada Beverage were already defendants in the same action, and Daniel Taylor disclosed his purchases from Terrible Herbst through the Nevada Beverage chain of distribution. I didn't think an amendment was even necessary. But through conversations with Terrible Herbst counsel, they specifically requested that we file the motion to amend the complaint just to make it abundantly clear that Daniel Taylor purchased from Terrible Herbst and his claims apply to Terrible Herbst Nevada Beverage. That letter is requesting us to amend is Exhibit 1 to the reply brief. So we agreed to at Terrible Herbst's request to file the motion. We filed the motion, we filed it timely. So it's hard for me to imagine how moving to amend at the request of one of the defendants who were amending against before the deadline to amend pleadings can be considered bad faith or undue delay or any of the strong reasons that are required to overcome the extreme liberality that's granted in allowing these types of amendments. So it doesn't change the nature of the claims that Nevada Beverage is already defending. It just adds the plaintiff additional medical records, and they've had plenty of time to address those now, and we still have plenty of time before trial in October. So for all those reasons, Your Honor, we'd ask that the court grant the motion as to Daniel Taylor against Nevada Beverage.
okay, thank you, sir. And let's hear from the opposition.
Thank you, Your Honor. Good morning. Colt Dodrill, Bar 9000, counsel for Nevada Beverage. The main reason we are opposing this motion is based on futility. It's futile because Daniel Taylor is now seeking to add claims against Nevada Beverage past the statute of limitations. We all know there's a 2-year statute of limitations. It's passed. Plaintiff's only argument is that it relates back, and it does not. The only thing I agree with is we look to Rule 15. Rule 15C tells us specifically that whenever the claim or defense asserted in the amended pleading arose out of the conduct, transaction, or occurrence set forth or attempted to be set forth in the original pleading, the amendment relates back to the date of the original pleading. Well, nowhere in the original complaint are there any transactions related to Daniel Taylor purchasing real water from Terrible Herbst. I was not a party, I being Nevada Beverage. Nevada Beverage was not a party to this suit in 2021. We were brought in 2023 when Taquante Henry, a different plaintiff, changed his mind as to which stores he thinks he purchased real water from. And nowhere in that amended complaint in 2023 is there any attempt to say that Daniel Taylor purchased real water from Terrible Herbst. We were not even aware of his fact sheet until a month after the statute of limitations ran. We were not aware of it There was no attempt by anybody until near the close of discovery to tell us, oh, hey, we want to add this entire plaintiff against Nevada Beverage. There's been no Nevada Beverage allegations in the original complaint, no allegations by Daniel Taylor in the amended complaint, no attempt by Daniel Taylor to allege any transactions related to Nevada Beverage until after the statute of limitations is required. So we're not trying to get a procedural gotcha. We're not trying to say, oh, it was late, it's bad faith, it's some procedural issue. No, this is substantive futility based on an expired claim because the statute of limitations had run. And I reviewed plaintiff's reply, which basically tries to throw Nevada Beverage out with Terrible Herbst bathwater. That doesn't work. The Terrible Herbst compromise is immaterial as to whether Daniel Taylor's purported claims against Nevada Beverage were expired. They're expired. I've not compromised the claims. I've not been aware of Daniel Taylor making a claim until after they were expired. And for Daniel Taylor to say, well, this is, you should have known because you were in other real water litigations, is a non sequitur. So I'd ask that the court deny the motion to amend based on futility.
All right, I have a question in that regard because I do realize you cited Rule 15. I get that. And I look back historically, I remember one of the primary issues regarding motions to amend and relate back pre Costello versus Kassler. There used to be a Rule 10A analysis specifically under the Nuremberger decisions, right? But post Costello versus Kassler, and our Nevada Supreme Court really clarified motions to amend and relations back, and with a very clear and specific Rule 15C analysis. And what the Supreme Court said is this, and this is taken straight out of the case, an amended pleading adding a defendant that is filed after statute of limitations run will relate back to the date of the original pleading under NRCP 15C. This is straight out of the case, and it goes further. If the proper defendant receives actual notice of the action, I think that happened here. Everyone knew real water was ongoing. Secondly, knows that it's a proper party. Okay, it's a products defect case under 402A, a defective product unreasonably dangerous, and has not been misled to its prejudice by the amendment. But then I think didn't Justice Seda, wasn't she the one that authored this opinion? That's my recollection. But anyway, but she goes further. She said Rule 15C is to be liberally construed to allow relations back of the amended pleading where the imposing party will not be put to a disadvantage or no disadvantage. And she was really clear on that. And so I understand a straight Rule 15C analysis, but I want an analysis under Kassler. Because at the end of the day, our Nevada Supreme Court has been really clear as far as that's concerned. It's to be liberally construed to allow relations back. And there's more language in the case, but that's just taken out of some of the key paragraphs.
Your Honor, that is the key paragraph in holding. And to answer Your Honor's question, the three elements, did Nevada Beverage receive actual notice of the action? They've been in this action since before the statute of limitations. So there's no question they received actual notice of it. We're not trying to bring them in out of the blue.
No, I understand that. I do.
So number two is knows that it is the proper party. They don't dispute that they distributed real water to Terrible Herbst. That's not a dispute. They're a proper party, that they know it. And number three has not been misled to its prejudice by the amendment. And that goes back to what my argument was in the first part was we amended this at the request of one of the defendants. It's timely. It's the same, substantially the same claims that they've been defending for years. The only addition is some additional medical records review related to one plaintiff. And that is not prejudice at all, let alone substantial prejudice to overcome the extreme liberality that Nevada law is well settled on in terms of allowing leave to amend so that these claims can be tried on their merit. So the key Costello case, which we analyze in our reply brief, we think that this motion should be granted.
Right, any comment on Costello?
Yes, Your Honor, thank you. And I did brief Costello as well, especially that second prong, which is that the defendant, which is in this case Nevada Beverage, knows that it is the proper party. There is nothing in the record to suggest that Nevada Beverage knew it was the proper party to Daniel Taylor's claims. Daniel Taylor did not say in his amended complaint or in any complaint prior to this motion that he purchased real water from Nevada Beverage. Nevada Beverage did not distribute all the real water, and as the court knows from other trials and other hearings, Nevada Beverage did not distribute the real water, the 5-gallon bottles, and to certain stores that were involved in the other cases. I only distributed to the convenience stores and the grocery stores. And there were no allegations in that complaint to tell Nevada Beverage, hey, you know that Daniel Taylor drank your water. There's nothing there in the first complaint. There's nothing there in the amended complaint. They only said, hey, guess what? Taquante Henry now purchased from Terrible Herbst. Okay, now I am in and I know about Taquante Henry. There's nothing suggesting we knew about Daniel Taylor until April 19. So how can we know? The Costello elements aren't satisfied here, and the Costello case can't be read so far as to say we can reach all the way back in time and pull Nevada Beverage in to a case because Daniel Taylor didn't tell us he drank real water purchased from Terrible Herbst. So under Costello, the motion should be denied.
Get the last word, Jim.
Your Honor, first of all, they did know that Daniel Taylor purchased real water from Terrible Herbst because it was in his fact sheet that was disclosed to them. So they knew, they had that information, but that's not the test. The test is, they're in the action. They know that they sold real water. They're a proper party in this case. The concern that he's talking about when you don't know is when you're some unaffiliated entity who is suddenly being dragged into a suit years later when you had no notice of the action was going on, you had no notice that you were potentially a proper party in it, and you've lost evidence and things like that. That's not the case here. They've been in the action since before the statute of limitations. The real water action in whole is enough, but they've been in this specific case. They've looked at the plaintiff's fact sheets that disclosed all their purchases. This is only a question of, oh, was the allegation clear enough in the complaint, which is just notice pleading. And clearly, we think that it was to begin with, that it shouldn't matter. But we only did this amendment to clarify because Terrible Herbst asked us. And why did they ask us? Because they looked at the fact sheet, they saw that he purchased from Terrible Herbst, and they said, hey, we want you to be clear if you're asserting a claim against Terrible Herbst, because it seems like you are, because he purchased from Terrible Herbst. So we'd like it to be clear in the complaint. Will you please amend? And that's what we did.
All right. I just have a couple of comments. Looking at the second prong, knows that it's a proper party. It doesn't say knows it's a proper party in prior pleadings. Doesn't say that. Number one. Number two, if that was really what it meant and they had to be identified as proper parties in prior pleadings, there'd be no need for a motion to amend. Right? There wouldn't be. Just making it very basic. And here's my decision. And I've had a chance to review Costello and the pleadings. And I will say this, that Costello changed in a significant way the evaluation and interpretation of motions to amend, because anyone that's been here in this jurisdiction for a long time remembers the day of the Nuremberger and all those progeny of cases and the type of analysis you had to go through under Rule 10, right, to amend and add parties. Justice Seda and her decision and Costello changes everything. It really does. And she even says it's to be liberally granted. I'm going to grant the motion. And I just interpret Costello slightly different because it says knows that it's a proper party. That's broad. right? It didn't say proper party and prior pleadings. Right? It doesn't say that. And if they knew, if they were properly identified in proper pleadings, there wouldn't be motions to amend. Motion granted, prepare the order.
Thank you, Your Honor.
Everyone enjoy your day.
You too, Your Honor. Thank you.